Hello, this is Kevin Thompson from Davis McGrath. I'd like to welcome you to the Davis McGrath LLC IP webinar series. Today's topic is copyright and fair use, and this is the webinar for February 8th, 2012. The recording and slides will be posted at our blog, which is located at the address on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for our mailing list. And new with this particular webinar is that we're going to be requesting Illinois MCLE credit. So those of you who are attorneys and need MCLE credit in Illinois, if you haven't already sent me your name and ARDC number, please do so. Our next webinar is coming up on March 7th, 2012, again for about half an hour, where the topic for that will be trademarks and domain names. So today we're going to go for about 30 minutes. And we're going to talk about, in general, what is copyright infringement, what are the defenses to copyright infringement, and specifically we're going to focus on one of those, which is fair use. And we're going to be talking about some particular fair use cases, as well as an offshoot of fair use, parody, which is one particular type of fair use. And then I hope to go and provide an overview of a recent dispute, the Shepard Fairey case with the Associated Press over his artwork involving President Obama. So I certainly think we'll go ahead and get started now. The first is copyright has certain rights that we've talked about in more detail in prior webinars, such as our copyright basics. So just in general here, we're just going to repeat a little bit of that and talk about these specific rights that are given to the copyright holder. The first is, the biggest is the right to reproduce the work, and then the right to prepare derivative works, such as works that are based on the original. There is the right to distribute copies, the right to perform the work publicly, the right to display the work publicly, and also the right for sound recordings to perform the work by means of a digital audio transmission. And fair use is certainly one of the rights, one of the aspects that affects these rights, such as the right to reproduce the work and the right to prepare derivative works. We talk a little bit more about that in a few seconds. Copyright infringement is defined as an action by someone who's not the owner that usurps or interferes with one or more of those particular exclusive rights. And if there is infringement, the copyright owner is entitled to injunctive relief. They can go to court and get a court to order the stop of distribution or sale. They can have the particular work impounded or destroyed. They can get compensation, such as damages and profits, as well as costs and attorney fees in the right circumstances. For example, if it's a registered work and the work is registered before the infringement occurs, you can certainly get costs and attorney's fees. And you're also, at that point, likely eligible for statutory damages, which is an election made by the copyright owner. They range from $750 to $30,000, but in the case of willful infringement, it could be increased to $150,000. And if a judge believes that the infringement that at issue is innocent, he can lower the damages down to $200 in the judge's discretion. So it's important to note that innocent infringement is not a defense. Innocent infringement, as we just discussed, reduces the amount of damages. But among the other defenses that do exist is fair use, which is the right to take something like a portion of, or in some cases even the whole of what is used, and there's a certain 4 factors we'll be talking about in a few seconds here. Parody. Another defense would be invalidity of copyright. So if it's a defense if the copyright was invalid or improperly obtained. Estoppel. So if there's actual facts that the person can point to show that this person should not be enjoined. Misuse or unclean hands, if the copyright owner has abused the due process, or there's some particular reason that their actions are improper, that certainly can be an issue. Improper notice, which is less of an issue today in that notice is not required, but under certain old laws that certainly was an issue. So if the work had been registered prior to the current act, that could be an issue. Also, should be noted is that there's a 3-year statute of limitations for copyright actions, and there's also an equitable doctrine called laches that could also apply. So if the person knew or should have known of their rights and doesn't take action, then this equitable doctrine can also bar enforcement. So now we're going to talk in particular about fair use, which is an area where there's a lot of misunderstandings, I believe, about just exactly what is fair use, and it's important to note that fair use is a defense to infringement. So if what you've done is found not to be a fair use, you still potentially could be liable for the infringement if there aren't other issues that would prevent that. But you certainly could be found liable. So there's a 4-factor test that's set out in Section 107 of the Copyright Act. Section 107 is one of those limitations on the exclusive rights, and it's primarily meant for particular purposes, such as criticism, commentary, news reporting, teaching, scholarship or research. Those are the types of things that are specifically set forth in Section 107 as potential uses of fair use. But that doesn't define or doesn't limit what actually could be considered fair use of copyrighted work. Instead, there's a 4-factor test that's set forth there that courts need to apply. And these 4 factors, and we're going to go through each one of these individually. The first is the purpose and character of the use. The second is the nature of the copyrighted work. The third is the amount and substantiality of the portion used. And the fourth is the effect of the use on the market for the copyrighted work. So turning to the first factor, the purpose and character of the use. And then the court looks at just what it is that's the underlying work that is claiming fair use. One of the important things to look at is whether it is a commercial use or whether it's a non-commercial use. And it's not really determinative in itself, but there's sort of a presumption that commercial use is less likely to be fair use, but it's by no means does that mean that commercial uses can't be fair uses, but it certainly weighs against it. So if the work is for a particular non-commercial use, such as for education or for just general First Amendment reasons, that certainly could be a factor towards finding a fair use. Another thing is looking at what is the purpose of this. Is this comment? Is this commentary? Is this criticism? And then another thing that they look at is how transformative of this is this of the original. Does it merely copy the original, in which case there's less likely to be fair use, or does it transform it into something different, something new? And then is the use merely incidental? And an example here would be like a news reporter who happens to be reporting in front of a piece of artwork. The copyright owner in the piece of artwork likely would not be able to complain too much because this use, this display of their copyrighted work was merely incidental. It was not the purpose of the use to copy the original. It just merely happened to be in the background. So that's the first factor, the purpose and character of the use of the work that was created. And the second factor that's looked at is the nature of the copyrighted work. Just what it is that's being copied. One thing to look at is how creative is the original. So if the original is a very creative work, then usually it is much more protection. But if it's work that is more informational or factual, it certainly could get less protection. And then another factor is whether was the original a published work or was the original an unpublished work. And as mentioned in our Copyright Basics webinar, publication in the copyright sense doesn't necessarily mean published in our normal sense, such as a book. Publication is usually when the copies are distributed or sold. And so if the original is published in that sense, then there's a good chance that there's or more likely to be a fair use of that work. There's more protection given for unpublished works because what the courts wouldn't want to do is allow someone to lose the right to make the original splash or the original introduction of the work, the original publication. And so for fair use of an unpublished work it's a little harder to argue. And then the third factor is the amount and substantiality of the portion used. And courts look at just how much is taken of the original. Is it a complete copy? Is it just part of it? And then how central to the original is the portion that was taken? And one of the cases we'll talk about really highlights this section here. How important to the original was the section that was used. And then the final one, some courts say is the most important factor, which is the effect of the use on the market for the copyrighted work. So will this work that's claiming fair use, will it replace the original in the marketplace? So would somebody no longer want to purchase the original, but then instead get if this person wants to buy the fair use version as opposed to the original, then it's less likely to be considered fair use. And so now we're going to focus on some particular cases. I just talk about these a little briefly. These are sort of important, famous cases that sort of illustrate this proceeding. Sony Corp of America versus Universal City Studios is a Supreme Court case from 1984. Some of you may realize that this is the Betamax case, and what that involved is Sony was being sued by Universal Studios for introducing the VCR technology, in this case the Betamax, claiming, among other things, that it was copyright infringement, and that also that the machines contributed to infringement as well. In this case, the court looked at the practice of time shifting, which is using a VCR to record a program for a later viewing, when that was considered a fair use because it was non-commercial and there was little likelihood of harm to the potential market for the copyrighted works. So, there certainly could be other infringing uses, but focusing on that one particular aspect of the technology was considered a fair use. And also, the VCRs has substantial non-infringing uses. And so, it certainly is an important case, and one that sets forth, our modern entertainment system as it is. If it wasn't for this particular case, we wouldn't have VCRs, we wouldn't have DVRs, we wouldn't have a lot of these other technologies that we've come to rely on. The next one is fair use case involving the publication of Gerald Ford's autobiography. The case is Harper and Row Publishers versus Nation Enterprises. And this one's sort of an interesting case. Harper and Row is the original publisher, and they licensed to Time magazine the right to publish excerpts, but somebody managed to get to Nation Enterprises a copy of the manuscript before it was published, and Nation Enterprises published its own version of a quasi-review of the book, and what they did was they provided quotes of about 300 words from the original manuscript. And as a result, since Time magazine had been scooped, they refused to pay Harper and Row any more money for the publication. And so the court, since Harper and Row sues Nation Enterprises for copying what they consider to be the heart of the book, the most important 300 words. In this case, what they'd done is they published the section of the book in which Gerald Ford talks about his pardoning of Richard Nixon, and as a result, their argument was that this harmed the market for the book. They were unable to complete their proposed license to Time magazine, and so they were able to claim harm, that it affected the market for the copyrighted work, and also the third factor, the amount and substantiality of the portion used. And this again is a Supreme Court case from 1985, and what the court found that it was indeed not a fair use, to have copied that significant portion of the heart of the book, and also for affecting the market for that particular publication. A more recent case is Kelly versus Arribasoft. Arribasoft doesn't exist anymore. They became a website search engine called Ditto. So here it is a screenshot of the Ditto website. Essentially what it is was a search engine for images. And you could type in your query, and then you would see the result in thumbnail images. And then when you clicked on it, it would take you to the original. It would take you to the source. Sort of like Google Images, but a much earlier version of that. And in this case, Arribasoft is being sued by Kelly for the fact that their copyrighted works are being reproduced, in these thumbnail images sizes. And the court looked at it and believed that this is a Ninth Circuit case, I should mention. The Ninth Circuit looked at it and found that the images would not replace the market for the original. Nobody was going to use just the thumbnails as opposed to the originals, and so they weren't. Although technically the entire work was copied, it was done in such a small size that it was considered to be a fair use. Next, we're going to get into a particular type of fair use cases involving parody, which involves making fun of the original, essentially. And this is the Supreme Court case of Campbell versus AcuffRose Music, Inc., which is from 1994. The rap group Two Live Crew, represented by Mr. Campbell, is being sued for their version of the song Pretty Woman, which was the original was done by Roy Orbison. And so his family, the AcuffRose Music Inc. company, the estate, brought suit claiming that this parody of the original Pretty Woman using rap lyrics was was an infringement. And this is a really great case to read. I certainly would recommend that for anyone really interested in a really thorough discussion of the fair use principles, especially when it comes to parody. They looked at the use was commercial. This new work added something new with a different expression and meaning. The pretty woman in the rap version was by no means the same pretty woman in the original. It was a different subject. It certainly had new meaning with the different lyrics that the Two Life Crew group had done. There was parodies almost always copy the original, so in some fashion. So the second factor didn't really work. Regarding to the amount of substantiality, the court stated that even though the heart of the Orbison song was taken, it's needed in order to conjure up the original for this parody version. And then for the fourth factor, there was really no evidence that that people would prefer to buy the Two Life Crew version versus the original Roy Orbison version. And so as a result, it was deemed to be a fair use parody. Now, turning to another parody that was found not to be fair use, there's the case of Dr. Seuss Enterprises LP versus Penguin Books, which is a really interesting case as well. The Penguin Books published a book called The Cat Not in the Hat, which they claimed was a parody of the Dr. Seuss original Cat in the Hat. But actuality, what it is was it's more of a commentary on the O.J. Simpson trial. As you can see for the image here, the cat is O.J. Simpson. He is wearing the cat hat, which is the 2 white stripes and 3 reds, but he's also carrying a bloody glove. And so this was purportedly attributed to a Dr. Juice as opposed to Dr. Seuss, and they claimed that what they had done was a parody. It certainly is, something that it certainly invites commentary and criticism here, but it's not commentary and criticism of the original book, and it's not truly a parody of The Cat in the Hat. It focuses on the O.J. Simpson trial, and as a result, it didn't parody the original in the sense that it did not focus on the original. It wasn't a parody itself of the original. It merely copied the style of the Cat in the Hat book in order to make its parody of the O.J. Simpson trial. And so since it did not comment on the original and did not focus as much on the original, it was found not to be a fair use. Again, it's also very certainly interesting reading. Now we're going to focus on for the last part of our series here on a more recent case, the Shepard Fairey versus Associated Press case. Very briefly, the facts are the poster. This famous poster that was created by Shepard Fairey of Obama, called the Hope poster, was created during the 2008 campaign. It's based upon a photo by the Associated Press photographer Manny Garcia. Let's see. The AP claims he was that Fairey owed them for licensing because he took the original photo and modified it. Meanwhile, Garcia, who was the photographer, claimed he still owned the copyright since he was a freelancer and did not, consent to this particular lawsuit. So there's sort of a three-way battle over rights here. And so Fairey is trying to sort out who exactly owns the rights and so forth. So he sued for declaratory judgment, trying to assert his fair use rights under Section 107. And the case itself, I should mention, actually was settled prior to any resolution. There were some bad facts that came out through the course of litigation involving Mr. Fairey. He had at one point, claimed it one particular photograph that he'd used, and then when he realized it was another photograph, the one that AP was claiming was actually infringed, he modified documents and destroyed evidence to try to stick to his original version. And when that particular aspect of that was found out, the case settled shortly thereafter. But that aside, let's focus on the work itself. And so I'm going to put up here the images. And so you can see the original on the left, which is a cropped down version of an AP photograph. The original has Mr. Obama on the left. He's part of a larger picture. I believe the original has George Clooney a little bit farther to the left, but he's been cropped out of this particular photograph. Whereas on the right is the Shepard Fairey version, which was turned into this particular artwork. And as you can see, the work is certainly arguably transformative. It's by no means a strict slavish copying of the original, although you can still see the original in the artwork. In the right, Mr. Obama has a pin that's not present on the left. Certain colors are changed. Like he's wearing a blue tie on the left. Now the tie is red on the right. He does have the same pose. The same look in his face at the same angle, but the background is erased and replaced with a blue and red background, and certainly aspects of coloring and shading throughout the artwork is done for a particular effect. The use of red, white, and blue throughout so certainly adds this sort of First Amendment right, as Fairey argues, of political speech to to transform the original into this. And I certainly think this is a rather interesting work to look at. Now, looking at the four factors here. What's the purpose and character of this use? Fairey would argue that this was a fair use because it was political in nature. It was his First Amendment rights to make his political aspirations known through through his chosen medium, which is artwork, and he. So certainly was prepared to make that argument. It was a somewhat commercial work in that he was selling prints of this particular artwork, but at the same time, I do believe others sort of were allowed to license and use it for for their own political speech as well. The second factor, what was the nature of the copyrighted work? In this case, it was a news photograph. It was, one that certainly the AP, could have, licensed its, people would owe them a licensing fee for their use. It certainly was a published work. It was one that was widely distributed and was licensed. So that's how that particular factor would fare out. Next factor would be the amount and substantiality of the portion used. In this case, what's been used is the sort of the essence of Obama, Fairey would argue, in that it is his the angle by which his head is at, the look in his eyes, just the general pose has been copied, but the rest of the work has been transformed. It's certainly certain aspects of the original, and it's certainly by no means an exact slavish copy of the original. And then the final factor, which is the effect of the use on the market for the copyrighted work. In this case, Fairey would argue that it certainly did not affect the market for the original. The market for news photographs is a fairly limited one. They're usually sold or licensed within a short news related aspect of the life of the photograph, and when it's no longer news, that affects the life of it. Whereas he would argue that this really didn't affect the market for that work. The Associated Press, of course, has different arguments to make. They would say, this was certainly a commercial use. This was, done to, profit off, the original authorship of their photographer Manny Garcia. That it's done for commercial gain. The nature of the copyrighted work, such as it is that it certainly would be a creative work. It's not your standard photograph. This is not, Obama was not normally seen in this particular pose. So there was just this one particular pose, and it was only this one photograph that could be used, as the basis for the original. As the basis for the copy. And then, they would argue that it's not just, the background, it's that creative expression, it's that, capturing of Obama in that particular pose was what's taken. And so they would argue that it certainly was a very large portion of the original that was taken. And they certainly would affect, argue for the effect of the market is such that, they were out, certain licensing fees for their use there. And it is rather unfortunate that we'll never really truly have an answer one way or the other, about, this use, whether or not it would be fair use, because as I said before, the case settled. Its cases often do. When they are going through litigation, it's always, cases never quite turn out exactly the way you intend, even copyright cases. So I think that takes me to the end of what I'd planned to say. What I certainly would like to do is open this up to questions at any point here. You certainly could have done questions earlier throughout using the webinar software. So we're going to pause here for a few seconds here to see if anybody has any questions. Okay, we do have one question from Pratik. The question is, how can you define the level of parody? That's really a good question. Parody are usually looked at as a form of social commentary or criticism on the original. It's something that an original author is not likely to allow the original to do. So certainly there are artists such as Weird Al Yankovic, who makes parody versions of songs, although he certainly would be within his fair use rights to proceed without the copyright owner's permission. His policy is not to make parodies of songs without the copyright owner's permission. It's just his own personal belief. He doesn't necessarily have to do that. And so, parody, it's well, what's required there is that it takes no more than what's required to evoke the original. It must conjure up the original and link the parody with the original in the listener's mind or the viewer's mind, depending on the nature of the work. And so if it's merely a copy of the original, then it's not fair use. It's a copy. But if it transforms the original into some new social commentary or criticism of the original, then by all means it can be considered a parody. So really, that's what they look at is how much is taken and how much it conjures up the original. So I hope that answers your question, Pratik. Does anybody else have any questions? Question from Mr. Mangan. Are there any pending copyright cases before the Supreme Court now? And what other cases on copyright should we be following? That's a good question, and one that I'll have to get back to you on. I do believe that there is some cases currently before them that may affect copyright, but I don't believe any of them involve fair use. Let me look into that and I'll get back to you. Another question from Pratik is, since I mentioned Ditto, what do you think of the SEO industry? Well, that's a little bit far from where we are here. I was mainly talking about that one particular case involving involving that particular aspect of fair use. It's certainly SEO is something which can impact copyright if people are taking certain things like the thumbnails and so forth. But I think that the Kelly versus Arriba is an important case for talking about the right to use the images. Well, I do believe that's the end of the questions that I see here. If anybody else has questions, please feel free to contact me. And also, if you are viewing this webinar and the recorded version, and you would like Illinois MCLE credits, please contact me with your questions. And also, if you have would like credit, you need to give me your name and ARDC number. Again, as a reminder, next webinar is coming up on March 7th, 2012 on the topic of trademarks and domain names. And a reminder, this recording and our other prior webinars are up on the address on your screen, which is blog.davismcgrath.com/webinars. So I certainly would like to thank everyone for attending, and I wish you all a good day. Thank you.